Welcome everyone and hello. I am Laura Cooper, and Katia Moran and I lead the Youth Justice Legal Centre at Just for Kids Law. This is the launch of our 11th and 12th guide in our series of legal guides that we have been producing together with the children's rights group at Doughty Street Chambers. And each of the guides that we have produced are on a key youth justice topic, and they're intended to be practical tools to help you fight for better outcomes for children. So before we start today, I just wanted to mention that last month we launched our YJLC, Youth Justice Legal Centre training and membership programme. So we're going to be having a lot more training and youth justice events coming up. So please check out our newsletter and our website for more information on that. So the guide we're launching today are entitled Children Facing Sexual Allegations and Sexting. And as we explain in the guide, the impact of the allegations of sexual offences on children are often significant and lifelong. The stigma attached to these allegations can be particularly traumatic. Myself and Ruth, is the lawyer that runs our Youth Justice Legal Advice Line, I think can both attest to the fact that dealing with some of these cases on our advice line and providing advice to families in these cases can be some of the most upsetting and sensitive cases that we deal with. As many of you will, I'm sure, agree, the answer will very often be in preventing the criminalisation of children for these cases altogether and looking at alternative therapeutic and welfare options for children. So the guides themselves, they provide an overview of the key sexual offences in this area, as well as advice on, dealing with the crucial stages of the case, all the way from the initial allegation to sentence. And we also provide practical tips along the way. So we're extremely grateful to Anya Kervik, Sandra Paul, Ben Newton and Jen Twite for their enormously helpful contributions in getting the guides together and ready to be published. And to discuss the issues a bit more, we've brought together a panel of leading experts. So we have Maeve Kean, a solicitor at Kingsley Napley LLP. We have Ben Newton, a barrister at Doughty Street Chambers, and Dr. Oliver Eastman, a consultant clinical psychologist at the NSPCC. Really quickly before we get going, the webinar is meant to be an hour and a half, but may finish a little earlier. It's being recorded, so there'll be a recording available on our website later. And following the presentations, we'll have a bit of a Q&A at the end. So if you'd like to address any questions to a particular panelist, just put their name at the start of the question. And for those of you on Twitter, we use the hashtag Youth Justice Guides if anyone would like to tweet. So I will now pass you over to our first speaker. That's Maeve Kean from Kingsley Napley LLP. Maeve is a solicitor specialising in criminal litigation, and her day-to-day work includes a busy crime practice, advising both children and adults. And she has acted for children facing a range of offences, including drug offences, allegations of violence, and both historical and current sexual offences. So over to you, Maeve.
Hello, everyone. My name is Maeve Kean, and as Laura kindly mentioned, I am an associate at Kingsley Napley. So first of all, I just wanted to say a huge thank you to the Youth Justice Legal Centre in Doughty Street for having me at this really brilliant event, launching these really important guides. And I'm so grateful to have the opportunity to be able to speak on this topic. I must mention at the beginning that it's actually my colleague Sandra and Anya, as Laura mentioned, that did lots of the drafting on these brilliant guides. So all credit must go to them. I will be speaking for the next 10 minutes or so about the pre-charge considerations when you're dealing with an investigation with a child that's been involved with an allegation of a sexual nature. Now, this, of course, will encompass a broad range of offences and scenarios, but I hope just to give you an overview of some of the practical issues specific to children and young people that we have seen crop up in our practice, and hopefully share some tips on how we navigate them. I'll briefly touch on school complaints, arrests, interviews under caution, and written representations. I'm also really interested to learn how other practitioners are dealing with these issues. Our approach is always evolving, and there really is no one size fits all. So I'm very keen to hear other views during the discussion at the end. So while being accused of a sexual offence carries a huge amount of stigma, regardless of your age, it really can have a life-altering impact on a child or young person. When a child comes to us that's been accused of a sexual offence, they can be scared, embarrassed, really worried about their future. And we've seen how outside of the investigation, the allegation alone can mean that they have been ostracised from their peers, excluded from education, or experience a social media pile-on where these allegations are put online. I am a really big believer that, particularly when dealing with children accused of these sorts of offences, that you can make a real impact in the pre-charge stage, making the effort early on to engage with investigators to ensure that your client is seen not as a sex offender or predator, but a child first and foremost. And that can really impact on how the investigation is conducted and ultimately get the best outcome for your client. So yes, that is the first slide. So I will look at first school complaints, and this is the very point where the allegation may be made. It's something that's specific to young people and must be considered from the very outset. Where a school may get involved in some way. It might be because the allegation has been made at school, involves two students. It may be involving a student at a different school, but your client's school gets involved, or it may seem completely disconnected from the school, but somehow they take action against your client. We've seen a huge increase in school-related complaints, as I'm sure a lot of people have, following Everyone's Invited. And schools will have their own policies, but a lot are very worried about getting bad press of not dealing with allegations properly, so it can be a bit reactive. So there's many ways that a complaint at school may end up as a criminal investigation. The first one may be if a student confides in a teacher, for example, and the teacher then goes to the police. Equally, it may be that allegation is shared with the school, and the school decide that the most appropriate action is to let the local authority know, and the local authority may do their own investigations, and they may notify the police. It may also happen the other way around. So if the police get a report, they may decide to tell social services, and social services may then notify the school. So there's a lot of information sharing with these bodies in the name of safeguarding children and young people. But not every school will deal with a sexual allegation in the same way. There's naturally a heightened sensitivity to sexual offences, and we've seen schools sometimes panic, report the matter to the police straight away, suspend the pupil, and do everything they can to protect their reputation, regardless of the impact that it might have on the child or even the seriousness of the allegation. The golden rule when dealing with a school, or if a school is involved, is that you must work on the assumption that everything that is said to the school will be shared with the police. And that is really key when there's a police investigation, maybe not even in progress just yet. If it's ongoing, definitely make sure that you advise your client not to discuss the specifics of the allegation with the school. But we've seen instances where schools sometimes will start their own investigation, take accounts from various students, and then bring our client into the school and ask them loads of questions about what happened, and then they pass that on to the police. And doing this sort of ham-fisted information collecting at the beginning, it can be a real issue, because it means your client may have given an account to the school without any of the safeguards that they should have been afforded when they're being asked in an interview under caution. In fairness, a lot of schools will be, trying to navigate and do their best, and some teachers may simply be checking in on your client about their well-being, but it is really important to remind your client that they they should feel empowered to say that they cannot discuss the allegation with their teachers, and maybe even giving them some language to use so that they can feel more equipped if the topic comes up. You know, just, I'm sorry, I've been told that I can't talk about what happened, but yes, I'm finding it really stressful. Just having a little line ready so that they don't feel pressurized or concerned if teachers ask any questions that they know they shouldn't be doing, but in practice, I've seen it happen all too often. Equally, it may be helpful to speak to your clients about making sure that they don't discuss the allegation with other students. Again, they can pass on some information to their peers and friends that then turns into a rumour that there ends up with a teacher, and the teacher then passes that on to the school and the police. Many schools actually will immediately suspend a student in the name of safeguarding when an allegation of a sexual offence has been made. And we've seen students excluded from school with immediate effect, even when they've got exams upcoming and there's not really any plan in place for them to be able to continue with their education. We've had the schools say, well, we're not going to allow the student back into class until we know the outcome of the police investigation. And they will sometimes call this suspension a neutral act. It's a neutral act. We're suspending your client, but it's only because we don't know what will happen. And that can be really problematic because we know that police investigations rarely are resolved very quickly. And it's usually a matter of years, you know, or months until they're able to come up with an outcome. One tip is if you have parents, guardians, or, you know, a person, caregiver, and that's engaged, you can encourage them to have a dialogue with the school. So to try and make sure that the client can continue to access education while this is all ongoing in the background. Another important point to remember with the school environment is when you're dealing with bail. So if an officer is proposing to put a bail condition in place to pre-charge, such as do not contact the complainant, you have to ask yourself, how would this work if they're in the same class, or say they play on the same football team after school? Can the bail condition be tailored so that it can allow both parties to continue with either their education or after school activities? So for example, we had one quite recently where a bail condition was put in place to not contact the complainant directly or indirectly, except for unavoidable contact at school, which is fairly broad, but it meant that if our client happened to bump into the complainant in the corridor, which was very likely, they didn't have the anxiety that they may be breaching bail. Next slide, please. So that brings me on to the subject of arrest and when arresting a child that's been accused of a sexual offence is appropriate. In my opinion, there are going to be a very small proportion of instances where there's an actual necessity to arrest a child and young person of a sexual offence. And this is something I find particularly frustrating because we've seen quite a lot of bad practice on this recently. We've had children arrested at their homes very early in the morning for, you know, non-recent allegations, or worse still, we've had occasions where young people have been arrested at school, on school premises, and there's police guidance as to why this should really never happen except for very exceptional circumstances. But again, you know, we've seen it happen, and when that happens in front of all your peers and the rumour mill goes mad, even if the outcome down the line is that nothing happens, it's really difficult to reintegrate. And it's really hard, actually. Just the act of being arrested can have a huge impact on a child. You must consider just the trauma that can be involved. So we had a young man arrested at his home about 8 a.m. last week before school, and he was with his family. It was in relation to a non-recent allegation said to have taken place well over a year ago between himself and a student of his age. And when I last spoke to him, he said, I haven't actually been able to sleep since that happened. I keep getting flashbacks of being woken up with the police in my house. Now, that is horrific for anyone of any age, but particularly a young person. There's also, of course, consequences of having an arrest on your record. We're not going to go into criminal records in a lot of detail today, but that's another really important consideration in terms of arrest. So next slide, please. The first aim has to be avoiding arrest altogether if this is possible. And although it may seem counterintuitive, engaging with the police at a very early stage might help circumvent any perceived necessity for arrest. So if you become aware, for example, that a report has been made to a school, the school says that they're going to be passing this on to the police, you can ask for the officer's contact details and say, look, I'm the point of contact for this young person. If you want to speak to them, let me know. And if you can have that conversation early on about whether a client can attend voluntarily, finding a place and time that actually works for all the parties, this can just help show investigators that there are alternatives that they may just not have turned their mind to. Equally, you may be able to raise the point of whether an interview is even necessary at all. There'll be cases, for example, sexting, maybe a written statement under caution that's simply submitted without the client having to attend the police station may be a really good alternative. And we just think presenting options to officers can help them think a bit more clearly about whether arrest is necessary, because a lot of the time it's done quite thoughtlessly, in my view. I'm sure a lot of people on this call will be aware of the recent case of ST, and this was the case where the police were heavily criticised for arresting a 14-year-old boy at 5:30 in the morning in his family home and then detaining him for 6 hours. Now, it wasn't a sexual offence, but this case was really important because it affirmed a lot of the key principles which the police should be using to guide their conduct in this area. My favourite quote is actually on the previous slide, if that's okay. It notes that as a broad principle, the starting point must be that it is wrong not to differentiate between children and adults when considering the necessity of arrest and detention. So age has to be a central and obvious consideration to the police. And if you're speaking to them, you know, there's lots of great points in that case that I would implore you to have a look at if this issue comes up. Now, of course, there's going to be occasions where it's just not possible to have that conversation ahead of time and the police decide to show up unannounced anyway. In terms of what you can do at that stage, it is much trickier unless you can get yourself to the scene straight away and challenge the officer in that moment about, you know, why is this necessary? Can we do a voluntary interview? If you've got parents or guardians that are present at the time, you know, if you can speak to them on the phone and ask them to ask the officers those questions, you know, just query, why is this necessary, and if they can do it voluntarily, or even if you can speak to the officer over the phone, if you can't be there, it's worth a shot to try and make some reps. Equally, if you manage to get yourself to the police station before the child has been processed at the custody suite, you may have the chance to make reps to the arresting officer for the child to be de-arrested so that the interview can take place voluntarily. Ultimately, your best chance to avoid arrest is getting in touch nice and early, and it can be hard to make as much as an impact once the horse is bolted. Next slide, please. This brings me on to interviews under caution, and there are, of course, lots of considerations that you generally have to be aware of when dealing with a young person being interviewed under caution. So I'll not repeat them. However, I just want to draw out a few points that are quite specific to those that are accused of sexual offences. And something that's really key to remember, and it's very obvious, of course, but discussing a sexual allegation in a police station with a child, you know, speaking to someone they've never met before or barely know, can be really, really embarrassing. This is important to remember when you're thinking about who can be the right appropriate adult. So for other offences, it may be a parent, a guardian, a caregiver that's best placed to be an appropriate adult. But when the offence is sexual, it's really important to be mindful of the fact that for many people, and myself included, discussing anything sexual in front of a parent is just their worst nightmare and may impair their ability to give, you know, proper, clear instructions. The other point is that the language in the disclosure may refer to sort of legal terms for sexual acts, so, you know, oral sex or digital penetration, and you can bet that that's not how they refer to it when they're talking about it. So making sure that your client understands what's actually meant by the offence and what the disclosure means is really important. just breaking down concepts like consent, talking it through, you know, what is a sexual assault, helping them really understand what is being alleged in language that they actually use is really key. Another technique I quite like to use is just reminding children that this is your day job and it's really hard to shock you. A lot of the time, the offences or, you know, the acts that they're talking about, if they mention them to one of their peers, they may get a bit of a reaction or a raised eyebrow. But I think it's really important to build that rapport and make them feel comfortable that they can talk about these things, and you're not going to immediately judge or you know, call them out or say anything about them. You have to give real particular consideration on how to approach the interview, of course, as well. And I've personally not come across a situation where I've advised a child in these circumstances to answer questions in interview. Now, that's not saying that there isn't a situation where that would be the correct advice, but I find that a prepared statement, quite a concise one covering the key issues that you need, with no comment to the rest of the questions, can be a really good way of ensuring that any sort of defences set out or any other factors that you want to raise at that point are put on the table. But it doesn't put your client in the really difficult position of being asked questions about something really uncomfortable, which, to be honest, is difficult enough at the best of times. The final point, just while you're in the police station, and what a point I'll make again, is just reminding the officer that your client is a child. You know, particularly for 16, 17-year-olds, they may look much older, but using the word child, using that language can be really effective in just continuing to keep that at the forefront of their mind. Next slide, please. The final point that I will, next slide again. The final point that I will just consider are written representations. And I think where you're dealing with a case where you've got a child that's been accused of sexual offences, it's definitely worth at least considering whether you should make written representations. Depending on the nature of the case, you may be in a position to push for the case to be, you know, not taken any further, or you may be presenting the benefits of an alternative to charge or an out-of-court disposal. It's a really good opportunity to remind prosecutors in writing of all the key pieces of guidance that they have to follow, and that's really helpfully listed in the guide that is published today. It's also a really good opportunity to draw out lots of the background and contextual factors which may not have been appropriate to bring up in an interview. So your client's background or family situation, any particular stressful events, these may be relevant for the prosecutor to know, but hadn't really had a good time to bring them up just yet. Again, I think it's quite a useful technique to use the word child in these representations, just to hammer home the fact that they are dealing with a child. You know, this is in relation to my client, a 14-year-old child. And in regards to the sort of arguments that you make, even where the evidential test may have been made if you're looking at a charging decision, I think it is really worth exploring the public interest factors when you're dealing with a young person and really setting out the importance of considering their age and maturity, as well as other mitigating factors, and reiterating the overall aim of the youth justice system to prevent reoffending. If you're trying to aim at out-of-court disposal, it's of course worth thinking about what sort of risks that the prosecutor may be worried about, and considering a package that may be able to help evidence that there are better ways of dealing with these behaviours. You know, you can consider if it's good for the client to get therapy or counselling, or in other instances it may be appropriate for them to suggest that they apologise for their behaviour. So I just think it's key to try and put yourself in the shoes of the prosecutor and what they will be thinking. Equally, if you've got a non-recent allegation, you may be able to point to a change in circumstances or some stabilising factors that were not present at the time of the alleged offending, and that would be relevant to considering what's in the best interest of the child now. There's also an incredibly important growing body of science regarding brain development, impulsivity, which I'm sure Dr. Eastman will talk about very soon, but it's useful to use the science to your advantage. And finally, you know, it's a consideration at any point of the proceedings, but whether it's worth getting an expert report early on that considers, your specific client's maturity levels and other factors that may be relevant in this early stage, so you can front load them with as much information as possible. So that's all I have. I know that was a whistle-stop tour of some of the issues that can crop up for clients accused of sexual offences in the pre-charge stage. I will hand back to Laura. Thank you.
Thank you, Maeve. That was really great, and there was a lot of really good practical advice there. So next, moving on, the next speaker is Ben Newton. He is a barrister at Doughty Street Chambers. He's going to tell us a little bit more about issues that arise at trial, as well as some examples of case studies from his practice. Ben Newton has practiced as a criminal defence barrister since 2004, and has practiced as 2004. He is instructed to defend those accused of the most serious and complex criminal offences, and regularly appears in high-profile and legally significant cases. His specialisms include serious sexual offences, and throughout his years, his practice, he has represented a significant number of children and young people accused of such crimes, as well as other offences, including murder. He also sits as a recorder in the Crown Court. Thank you, Ben.
Thank you very much, Laura. I think that's got to be the most mortifying part when you sit through your own introduction. So thank you very much for that. I'm glad that's over. So I'm going to pick up where Maeve left off and talk about the stage once you get to trial. Can I just check, Laura, can you tell me, are the slides...
the slides are coming up. Thank you very much, Ben.
Yeah, and they're not obstructed. Okay, good. Okay, fantastic. Thank you. So I'm going to pick up where Maeve left off, and thank you very much, Maeve, for such a fantastic overview of the initial stages of a case, because of course that's what really matters. And ultimately, if you get to the stage that I'm going to talk about tonight, then to some extent you're already in a situation you've been trying to avoid, because an awful lot of cases where we're advising children who are accused of sexual offences and representing them in the early stages at the police station, it's really about trying to avoid it going to court, and so much work is done for that. But if you do get to the point where it does go to court, then of course you've got to be ready to deal with it. And the first thing that crops up is the allocation decision when they make their first appearance, hopefully at the youth court, although I'll come back later to the fact that very often these days we're going to have children who have allegedly committed sexual offences who have been dealt with as adults, because unfortunately there's just so much delay prevalent in the system these days. But if you've got a child who is still a child at the time that they're charged, which in itself is something of a small victory, the first thing you have to deal with is the allocation issue at the youth court. And of course, there are three ways that this can go. You can have the youth court, magistrates court dealing with adults, or the Crown Court. Now, I'm going to focus tonight on the decision between staying in the youth court and going to the Crown Court, because realistically, the most common situation in which a youth ends up in the adult magistrates court is if they're jointly charged with an adult. And of course, when you're dealing with sexual offences, you can occasionally have multi-handed cases, but it's far more common to have defendants charged individually with sexual offences. And so it's unlikely you would deal with that situation very often. Now, the decision on allocation is influenced by the Sentencing Council's overarching guideline on sentencing children and young people, which, although it's a Sentencing Council document dealing with sentencing children, of course, the decision that is being made at allocation is effectively a forward-looking decision in terms of what may or may not happen at a sentencing stage. And so it's dealt with in quite some detail in that guideline. And practitioners will all be familiar with the notion of grave crimes being the crucial factor. Is the child or young person charged with a grave crime? And this flowchart, which is a little hard on the eye to start with, it is taken from that guideline and effectively is a pictorial route through that's, I think, designed as much for youth-trained magistrates making the decision as to anyone else. But what's changed in recent years is it used to be that it was a fairly cut and dried exercise in terms of whether or not an offence was or wasn't a grave crime, and whether at the end of the process it would be necessary for the child to be dealt with under what used to be section 91 and is now section 250 of the sentencing code, whether they would get a sentence of 2 years or more effectively if they were convicted of the offence. What's changed in the last few years is there's been an increasing culture and increasing guidance, which is now reflected in the Sentencing Council guideline, to encourage youth courts to retain jurisdiction in almost all circumstances, really, unless it's absolutely clear-cut for one of the other reasons. So, for instance, being charged with homicide or a firearms offence subject to a mandatory minimum. If you're not in one of those situations and it is coming down to whether or not it's a grave crime, so the second question on this flowchart, if you've not fallen into one of the categories on the first question, the presumption now is that a case will stay in the youth court and be dealt with unless it's absolutely clear that it's going to be beyond the youth court sentencing powers. And paragraph 2.10 of this Sentencing Council guidance specifically says that as there is now a power to commit grave crimes for sentence, i.e. after they've been tried in the youth court, the court should no longer take the prosecution case at its highest when deciding whether to retain jurisdiction. In most cases, it is likely to be impossible to decide whether there is a real prospect that a sentence in excess of 2 years detention will be imposed without knowing more about the facts of the case and the circumstances of the child or young person. So what you increasingly get now is the prospect of being tried in a summary jurisdiction, having a summary trial in the youth court, with the risk still lurking at the end of it of committal for sentence to the Crown Court, which an awful lot of practitioners would regard as being the worst of both worlds. Now, of course, it's not quite that straightforward. There are other advantages to a child of staying in the youth court, which might not be so obvious in relation to an adult staying in the magistrate's court. The obvious one is the fact that youth court proceedings take place in closed court. And so there's the privacy and the protection that comes along with that, which you don't have for a child in the Crown Court. Of course, you still have reporting restrictions for a child, but it's a very different situation when you're dealing with a Crown Court, which is an open court. And of course, the overall feel and ethos of it is very different. And even when a Crown Court removes wigs and gowns and takes into account the needs of a young defendant, you're still in a very, very different and more austere environment, both in the courtroom and outside the courtroom in the court building, compared to the much more protected environment of the youth court. You've also got a situation in the youth court where you've got a specialist district judge, usually on any sexual offence of any level of seriousness, or failing that, a youth trained bench, as opposed to the situation in the Crown Court with a judge who will be far less familiar with dealing with child defendants, and of course a jury. And so the whole situation is far more intimidating for a child in the Crown Court than the youth court. On the other hand, you do have the fact that in a Crown Court you get the benefit of a jury, which in many cases, particularly cases of sexual offences, will offer you a higher prospect of acquittal. And so often you would actually prefer to have a jury in a case of serious sexual allegations. And that's something that would obviously have to be weighed up. But of course, unlike with an adult, where a serious sex case is always going to have trial by jury, and even in the most minor of cases, you'd always have the right to elect jury trial, because all sexual offences are either way offences or indictable only. Here you face the possibility of being forced into a summary trial in circumstances where you may have wanted a jury. And this change in the guidance and the fact that the youth court can now retain jurisdiction, try the case, and then commit for sentence makes it all the more likely that will happen. So it's very important to have that in mind at the allocation stage. Now, once you get beyond that stage and you're in a situation of dealing with either summary trial or trial by jury, you go into the trial preparation stage. And there are very different challenges here. And Maeve really has already touched on quite a lot of this, so I'll be fairly brief on it. But one thing I think is really significant when you're in the trial preparation stage of a case is the role of parents, because what you've ultimately got is what feels like multiple clients. And whereas when you're representing an adult, they may occasionally have somebody with them who's got a keen interest in the case, sometimes a partner who's there side by side with them in conferences and keen to be involved and support them. When you're dealing with a child, obviously you do have the parents there playing a much more explicit and defined role, as opposed to just being a well-meaning bystander. And that can be positive or negative, depending on the effect that the parents have in conferences and the expectations that they bring to the case, and also the effect it has on the child in terms of whether or not they feel supported through the process, or whether or not the involvement of their parents throughout can actually just increase the pressure they feel and make them feel even more marginalised. So it's a very delicate balance in terms of dealing with the role of parents when you're in the pre-trial situation of taking instructions from a young client, and also from counsel's point of view in terms of having conferences. Now, I think one of the really crucial things that has to be done in a pre-trial phase when you've got a young defendant, and particularly with sexual offences, for the reasons that Maeve's already touched on in terms of the increased potential for embarrassment and them clamming up, is building that relationship and rapport from an early stage. And that's obviously a factor of what a solicitor needs to do in their relationship with their client. But I think it's even more stark when you've got a barrister involved. So either a case that's going to the Crown Court, or one where in the youth court you've got counsel instructed. Because the common mode is that barristers don't have a huge amount of contact with their clients before trial. You've got the traditional model of attendance at a plea and trial preparation hearing in the Crown Court, and then maybe a conference or two before trial. But really, a lot of the relationship that's built up between the barrister and the client is often done at trial, which is not ideal, to say the least, when you're dealing with a young defendant. Because for one thing, the distinction between the relationship between the solicitor and the barrister is something that's going to be more confusing for a child. But also, you've got that need to build trust from an early stage. And I think it's really important that you don't have a barrister representing a child at trial without having had the opportunity to build a relationship with them before the trial, not least so that on the eve of trial, they know the person who's going to be representing them, and it's a familiar face at court, and it's someone that they already feel comfortable with. So I think it is important for counsel to have more conferences with a young defendant facing sexual allegations than you might do with an adult, or indeed even a child facing less sensitive charges. Now, of course, in terms of the need for preparation, that's also vital, because a child is going to be far more intimidated by court proceedings than an adult, and that, quite aside from the emotional aspect of it and the need to safeguard them, is going to be significant in terms of their performance if they give evidence. And so it's in their own best interest in every conceivable sense, including the outcome of the case, for them to feel as comfortable as they can in the surroundings they're going to face at trial. So part of that is obviously building a relationship with the lawyers who are going to be there with them. But a lot of it also comes down to making sure that they have the fullest understanding possible of what it's going to be like in the courtroom situation. Now, that can start at the first appearance in the youth court, or the first hearing they have in the Crown Court if it goes to the Crown Court, in terms of taking that opportunity to try and get them used to those surroundings, explaining to them what it's going to be like at trial when they're there, while you're in that environment, talking them through it, explaining who's going to be where, what the process is going to involve. But also in conference scenarios, when talking ahead to the trial and talking about what it's going to mean when witnesses give evidence and they're cross-examined, what special measures might be in place for prosecution witnesses, what it's going to be like for them, where they're going to be, trying to get them used to those ideas in the pre-trial phase so that they're not absolutely blown away when they get to trial by how overwhelming the whole process is. Now, in terms of the trial itself, it's, as I've sought to indicate with that image, it's going to put a young person under an enormous amount of pressure, and any child, whether they're towards their early teens or getting towards their late teens, is going to feel under huge pressure at trial. And again, some of this comes down to preparation beforehand, but a lot of it can be dealt with in terms of what you do at court. So where is the child going to be in court? What can you ask the court to do to try and make it as easy a process for them as possible? Also, a child really ought to always be treated as a vulnerable witness by the court, even where they're the defendant. And whereas a youth court bench ought to be well aware of that, if you're in the Crown Court, it's very important for the judge to be reminded at an early stage and at every stage that effectively the defendant in the dock is a vulnerable witness at every stage of the process. So there may be adaptations that can be made that will make things easier for them. Some ought to go without saying in terms of things like removal of wigs and gowns, but also court sitting times, need for breaks. Even in the Crown Court, a child ought to be sitting with their solicitor if their solicitor's in court, or proximate to counsel, or with the parent who's with them in court. And so they ought always to be in a situation where they've got immediate support around them and don't feel isolated. A very important factor is, of course, preparing them for talking openly if they're going to give evidence in court. And to some extent, that involves not desensitizing them to the concepts and the issues that are being dealt with, but certainly trying to take away the embarrassment factor. So I think it's really important in the preparation stages of a trial to try and talk as openly as possible with the client about the sexual matters they're dealing with, try and make them seem commonplace, take away the embarrassment, take away the stigma, get them used to it, get to a point where that initial awkwardness has disappeared, so they're used to talking about it. And then also trying to maintain that in the trial process, in the run-up to them giving evidence if they're going to, so that by the time they go into the witness box, it's not the first time they've used these words. It's not the first time they've talked in a way that's not euphemistic or using ways of talking around the subject. And of course, at trial, again, you've got the question of family involvement and particularly parental involvement. The parents can play an absolutely vital role in supporting their child at trial, but equally, you might find that you have parents in some circumstances who are just not giving that degree of support. They're just not there. I've certainly defended children where the parent just hasn't come to court with them. It's a heartbreaking experience to see a child turning up at court, as I had in one case where it was their older sister who was there supporting them, who's barely older than them. The defendant was 16, the older sister was 18. It was entirely inappropriate that she was the one providing that level of support, but the parents just weren't interested, unfortunately. And so you've got to make the best of the situation and try and create that nurturing environment around them. On the other hand, you could have parents who are slightly overbearing, might add to the pressure that the child feels, might make it harder for them to talk openly in conference with you about the kind of issues and subject matter you need to talk about, might talk over them, might try and talk for them and be their advocate to great an extent, so that they end up being the voice in every situation, except in the witness box, which of course is the one place where the child, if they're going to give evidence, will have to speak for themselves, and they've done them no favours by not allowing them to prepare for it. So sometimes you've got to make a decision as to which parent is going to be better suited in the courtroom environment to giving the support. And I would suggest it's usually the one who's got a better grip on proceedings from their own emotional point of view, the one who's coping with it better themselves, because it's no help to a child if they've got a parent with them who's finding it difficult to cope with the process themselves and perhaps needs their own degree of support. So if you've got a parent who's keeping it together and is able to be the rock that your client needs, then they're the one who you want to encourage to be practically involved and perhaps try and find some sensitive way of keeping the other parent at arm's reach at crucial times, so that they're not increasing the pressure on the child. And of course, the last thing to talk about in terms of the trial stage is the fact that you do have the difficult question about whether or not the child is going to give evidence, and the issue of adverse inferences, which of course is something that runs over with what Maeve was talking about earlier, with decisions you make at interview and whether or not to give an account at interview, which can be a very difficult decision. Realistically, the decision there is not going to be completely different to a decision with an adult in terms of whether or not the child has an account that they need to give and the importance of them doing so. But the most important thing is that they make that decision from a position of not being frightened of giving evidence, so that you've got them ready for it as best you can, and they're not giving evidence simply because they're scared to go into the witness box, rather than because it's the right tactical decision in the case. Now, hopefully, if all goes well, you never reach the sentence stage. But of course, you may get to the sentence stage through an adverse outcome at trial. You may get to the sentence stage simply because the client has pleaded guilty, as will often be the right thing for them to do. As I said earlier, the delays that occur as a result of the backlog in the criminal justice system, the backlog with the police, the delay it takes an investigation and charge, can have an absolutely terrible effect on a young person. I'm currently advising a young man who's 18 in January in relation to allegations of things that he's supposed to have done when he was 13. And we've now got the race against time that if he's not charged by the end of January, he'll be an adult. Now, that may work in his favour, in that it will pretty much guarantee him a Crown Court trial if he's charged with Section 2 Sexual Offences Act, which is what he's being investigated for. But on the other hand, if he wanted to plead guilty, for instance, he's massively disadvantaged because he'll then be sentenced as an adult rather than as a child, which he should have been. The quote that I've put on screen comes from the Sentencing Council guidelines and sets out the important considerations that need to be made in thinking about sentencing a child. But what I want to focus on briefly here is this problem that we have now with the delays, meaning that more and more often a child will be sentenced as an adult for something that they did when they were a child and should have been dealt with when they were a child. And there is a differing purpose of sentence for adults and children, which I'm sure many people here will be familiar with. And so it's important to remember that when someone reaches the age of 18, the purpose of sentencing adult offenders is the punishment of offenders, the reduction of crime, the reform and rehabilitation of offenders, the protection of the public, and the making of reparation by offenders to persons affected by their offences, which is obviously very different from the purpose of sentencing with a child. And it seems rather unfair that those purposes should kick in just because a child has become an adult for something they did when they were a child. The law states quite clearly that a sentence shouldn't be more serious than it would have been if sentenced at the time. But there is a real tension between these two principles. The sentencing guidelines make very clear as well at paragraph 6.42 that a custodial sentence for a child should be a measure of last resort. But despite that, when you look, for instance, at the Sentencing Council guidelines that relate to sentencing children for sexual offences, the guidelines at step 1 immediately make clear that a custodial sentence or youth rehabilitation order with intensive supervision and surveillance or fostering might be justified where you're dealing with penetrative activity involving coercion, exploitation or pressure, use of threats against the victim, prolonged detention, sustained incident, or severe psychological or physical harm. So even the guidelines for sexual offences that specifically relate to children envisage certain types of offences where custody may well be appropriate, even though the overarching guidelines for sentencing children and young people make clear that custody should be a last resort. So you are up against that greater battle when you're dealing with the purposes of adult sentencing. And again, the guidelines say that if you are in that situation of dealing with sentencing using adult guidelines, even for a child, the court should be thinking in terms of a sentence of half to 2/3 of what the adult guideline would say for a child between 15 and 17 years of age. But again, of course, the problem there is half to 2/3 of a custodial starting point is still a custodial starting point. So again, there is this constant tide that's dragging you towards custodial sentences. And it's really important when dealing with sentencing for children and for children who've crossed the cusp of being 18, that the court is made to focus at all times on the fact that custody is a last resort, and to really try at all times to remind the court that they should only even be looking at an adult sentencing guideline that's considering custodial sentencing if they've already made the decision that it has to be a custodial sentence. Unless they make that decision, they shouldn't even be looking at that guideline. And so the additional flexibility is still there, but it's really important to make sure that the court don't lose sight of that through a sentencing process, particularly in the Crown Court, where you've got a judge who's just not used to the principles that ought to apply to the sentencing of children, because they very rarely do it. Laura, I hope I've done okay with timing on that. I think I might have gone a little bit over my 15 minutes, but...
No, that's great. Thank you very much for that, Ben. That was really good. Thank you so much. Just to remind everyone that if you will have any questions, do put them in the Q&A for us, and we can try and answer those after our last speaker. So our last speaker is Oliver Newton. He is a consultant clinical psychologist with the NSPCC. And he is, Oliver Eastman. Sorry, I'm confusing the surname. Sorry about that. Dr. Oliver Eastman. He is a consultant clinical psychologist who works in both private practice and frontline services. He has extensive experience of managing, developing and delivering services for children and young people displaying harmful sexual behaviour. He's currently the clinical lead within the National Clinical Assessment and Treatment Service. This is an NSPCC National Centre of Expertise on children and young people who sexually harm others. And he has a particular interest in developing a whole family response for children and families affected by sibling sexual abuse. So over to you, Oliver. Thank you very much for joining us.
very much. Yes, I'd like to say, just to start with, thank you very much to Laura and Katya and the Youth Justice Legal Centre for inviting me to come along and speak at this event. Next slide, please. So yes, I'll start just by acknowledging that harmful sexual behaviour displayed by children and young people is a fairly significant social problem. So what we know is that at least 1/3 of all sexual offences against children and young people in the UK are committed by other children and young people. But these behaviours are very diverse. So, you know, they can be online, offline, or both. They could be contact or non-contact or both. They could be relatively low level through to quite abusive and violent. They could be a one-off. They could be repeated. They could be historical or current. So they are all very different. Typically, these behaviours aren't directed towards strangers. So it's very rare for a young person to sexually harm a stranger. One study found only 3% directed towards strangers. So typically it will be someone that they know, such as a sibling, typically, or a relative, a peer, maybe a partner. Just in terms of the basics, so I'd probably comment on, well, I will comment on age. Age seems quite relevant. So what we know is that the peak age in terms of when young people come to the attention of services is 12. So this probably isn't a coincidence in terms of it coinciding with puberty. What we know is young boys can experience up to sort of an 800% increase in testosterone around this time, amongst many other changes. And this does seem very relevant. So for many young people, puberty is a trigger for feelings and problems to become sexualized, and they may well come into contact with services. There is a gendered element, even though we're talking about a very heterogeneous group. This typically is a boy problem. So at least 90% of all sexual offences are committed by boys. Some studies find higher levels. But there is a growing recognition that girls do engage in high levels of sexual harm than is being reported and recorded. One thing we do see is very high levels of adversity and trauma in the backgrounds of these children. So, for example, in our service, in NCATS, over 90% of the children and young people referred have experienced some form of abuse, neglect, exposure to domestic violence. Maybe in an attempt to organise our thinking, 3 broad categories of children and adolescents who sexually harm have been distinguished. So we have 3 groups. We have the abused group. In this group, the young person has typically experienced some form of physical, emotional, or sexual abuse. These children are classified as in need, and their harmful behaviour is understood as reactive and a response to their own abusive experiences. In the delinquent category, the young person doesn't necessarily specialise in sexual offending, but their harmful sexual behaviour is sort of viewed as an extension of a wider pattern of antisocial, delinquent, sort of boundary violating behaviours. And then we have the impaired group. That sort of incorporates anything really that could potentially impair their sort of healthy sexual functioning and understanding. So it might include special educational needs, learning difficulties, social communication difficulties. But what I would say clinically is that we often see that a child will sit across more than one group. They don't so neatly fit in real life. Next slide, please. I thought I'd briefly just share some reflections from working in this field for the last 15 years. I'll just pick out a few because of time. Maybe this doesn't need to be said, but these young people that we're talking about are not monsters, as depicted in that image. That is often how young people are thought about by professionals when an allegation comes to light. So they're not monsters, or at least I'm yet to meet one. These young children, they all have their own stories, and the overwhelming majority are actually very likable. They have multiple strengths and many redeeming qualities. There is another gender difference. So girls, in our experience clinically, girls receive a very different professional response to boys. So what we find is that professionals are better able to hold in mind the girl's developmental status and her trauma and vulnerability. For example, she is more likely to be seen first and foremost as a child, as Maeve talked about. So first and foremost as a child and someone deserving of support, protection, compassion, and understanding. However, this is often lost when a boy displays what can often be exactly the same sexual behavior. A shift takes place whereby they are seen more as a predator, someone who's dangerous and needs punishing. So we do definitely see a very different response. There's also sort of challenges with looking at the problem systemically. Often we'll tend to locate the problem in the child and try and fix the child. The child will get referred into services to be fixed. But what we need to do often is zooming out and looking at more sort of external or systemic influences on their behavior, typically their family environment. So they may be growing up, continue to be exposed to domestic violence, neglect, poor sexual boundaries, a lack of safety. And often they're referred to services for treatment. But at the end of their session each week, they'll just return back to exactly the same environment, which is these conditions that sort of led in part to these behaviors in the first place. So there's a real need to take a systemic response. An example would be in the Netherlands at the moment, is they have restorative approaches whereby, first of all, if a child has harmed a sibling, for example, what happens first is that the parents have a restorative conversation or write an apology letter to the child that's harmed. That's the first thing that's done. And only then will the child who's harmed the victim will then again have a restorative conversation or write an apology letter. So first of all, the child that's harmed is apologized to reflect, I guess, some of these systemic aspects. I'd say something else is that very few cases of harmful sexual behaviour are about sexual deviance with young people. I think most are about adolescence, most are a communication of distress, and their function is often to meet non-sexual needs, such as, for example, a desire for comfort. But yes, very rarely do we see sexual deviance, sexual attraction to children, for example, sexual arousal to young prepubescent children. We've seen a very sharp rise in cases of sibling sexual abuse over the last few years. Currently, about 80% of our cases are sibling cases. These cases, sibling cases, have been referred to as the last taboo. It's a bit of a hidden problem. But what we know is that a child is much more likely to be sexually abused by a sibling than anyone else in the home. And maybe the last reflection, which people may not know, is that in terms of risk, most children, most adolescents who sexually harm won't do it again, even without intervention. We know that sort of recidivism rates are somewhere around 10 to 15%. So what we know is much of adolescent sex offending is about adolescence. And I'll come on to that if we could move on to the next slide, please. So what we have here is a picture. Well, the eagle-eyed amongst you will notice that's not a Ferrari, that's a Lamborghini. But that's the best I could get. So adolescence has been referred to a Ferrari, being like a Ferrari without brakes. And so I suppose what's really important within my talk is just to acknowledge the importance of imposing a developmental lens on a young person's behaviour. We need to move away from viewing them as mini adults. This has already been talked about already by Ben and Maeve. So what we know is that the limbic system is the engine, in terms of the Ferrari analogy. It's highly charged in intense emotions and hormones, around the adolescent stage. The brake system is the prefrontal cortex. That's the part of the brain that's sort of responsible for executive control. So it's the bit that helps us make decisions, calculate risks, make plans for the future, and control our impulses. Critically, it's not developed until our mid-20s, and therefore it's frequently overridden by this very active limbic system. Why is this a problem? Well, because it brings a host of risks. So we can see that it's associated with more impulsivity, impaired judgment, a lack of consequential thinking, risk-taking. So in a young person's sort of decision-making, there'll be an over-focus on rewards rather than risks when they're thinking about what to do. Novelty-seeking, thrill-seeking, empathy levels are still developing. And basically, I think a lot of what drives or governs a child's behaviors, I'll go with what feels good. In addition to these, there's also other factors that are going on during this developmental stage of adolescence. It's a time when we transfer our attachment from our caregivers, from our parents, to our peer group. We start to spend much more time outside of the home with our peers. We're subject much more to peer pressure, to social conformity, fitting in, doing what other people are doing. There's much less adult supervision. And as we've already talked about, there's the issue of puberty, the onset of libido. This all goes on as well around about the age of 12, 11, 12, 13. All of a sudden, they're thinking a lot more about sex. So all of these things create vulnerability. But then if you layer that on top of a child who's already experienced early trauma and the impacts that that has on their neurobiology, and maybe other vulnerabilities, they may be they may have ADHD, be very impulsive, hyperactive. They may have learning difficulties and struggle to make sense and understand what's going on around them. They may be neurodiverse and have social communication difficulties. So one of the things that has been found in the research is that for adolescents who sexually offend, there's one survey that followed them up over 20 years. And what they found was that most of the reoffending occurred within the first couple of years. After that, it dropped off substantially. And in the last it was a 20-year follow-up, in the second 10 years, there's practically no reoffending. And what they've associated that with is adolescents get to a point in their mid-20s, a level of maturity. And it's with that maturity that could become comes a change in behavior, but also a change in circumstances. And so this developmental focus is considered to be really critical to understanding sexual acting out. Again, these vulnerabilities are captured quite nicely in this Steinberg and Scott paper, which talks about being less guilty by reason of adolescence. Next slide, please. So in terms of the impact of allegations, how do allegations impact on children, on their families? I guess the first thing to say is that it's a full range, really. We have many young people who really struggle to make sense, to understand the seriousness of what's happened. I was working with a family a couple of weeks ago, and dad was talking to me about how I was asking about the impact because they were subject to an investigation. And dad said that my son's just really angry with me because he's lost all of his devices. He blames me. He doesn't understand the seriousness of this. He's very naive. That the child's focus is simply on his access to his games. For other young people, they may have a very avoidant approach to problems. They may, a mum again I spoke to last week, she said she was very worried, but her son was burying his head in the sand, was trying not to think about it, was distracting himself. But then, of course, we also have children who become very, very anxious. The uncertainty of a very protracted investigation, maybe date to trial, all of that can create very long delays, a lot of uncertainty, a lot of fear and worry around what's going to happen to me. A lot of shame, particularly if people around them are aware of the allegation. And a lot of concern around the impact on their identity. For many children, an allegation of a sexual offence very much jars with their sense of who they are. And it's a very difficult thing to reconcile for them psychologically. I view myself this way, and yet I have an allegation hanging over me. And again, that can cause significant distress. Parents talk a lot about being on a journey. The idea that maybe a bit like grief in some respects, initially they may experience shock at the point of the police turning up at the house. Over time, it might turn to disbelief. My son wouldn't do that. Move maybe onto anger quite quickly around who's doing this to us, who's doing this to our family. Again, over the course of 18-month case, it might at some point move into fear and anxiety. What's going to become of my son? What about his goals in life? Will he be able to work? How do we tell people? What will they think? Or maybe guilt. Where did I go wrong? Why did he do it? Maybe confusion, but essentially a whole host of emotions. And there's also wider disruptions. So we often see at this point that children's services become involved, and that can often be experienced as very intrusive within families. As has already been discussed, the child might be removed from school, they may be removed from home and have to go and live elsewhere, particularly if it's a sibling case where there's an allegation of harm against a sibling. So there can be all sorts of wider disruptions that will impact on the young person's experience. And more generally, there's the isolation of not being able to tell anybody, and the protracted time that has such an impact. Next slide, please. Okay, I'll probably save some of this for the discussion around diversion because of time, but I suppose I'm thinking about how do we divert a child out of the system? How do we achieve better outcomes for children? I was in conversation only last week with the Lincoln Joint HSB diversionary panel. So in Lincoln, they have a specific HSB diversionary panel, and this seems to be very good practice. What they talked about is how it worked wonders in reducing court appearances and not criminalising young people. It was set up following meetings by the regional CPS and local sort of police management. And what they do is they take any offence, including indictable offences. They have 70 days to turn it around. The panel is multi-agency. It's police, practice supervisor, early help, school, complex needs, YOS officer. And what they do is they look at each case, and if there's a youth gravity matrix score of 3 or below, then they have the discretion. It sits with the panel around disposal. If it's gravity score of 4, then it goes back to the CPS, but they do send it back with recommendations. That to me, and so what they have is an established pathways locally in terms of an alternative to criminalisation, something that's robust. And I think that's one of the things that's missing, certainly locally to where, in London at least, is that we don't have these established panels or these pathways, so that me, for example, as an expert witness, whilst I might complete an assessment of a young person who's subject to an allegation, there are not those pathways set up in terms of it being able to go and be considered on a multi-agency level. And I think that's what gives it the teeth. But I do note that sort of, again, we can. I'll stop now with one last comment, and we can maybe return to it in the discussion. But I do think good communication with instructing solicitors tends to be the exception rather than the rule. Often cases can be referred, and often there's very little discussion before. Often there'll be a letter of instruction, but there won't often be a lot of discussion around sort of clarifying the questions, or even subsequent to sharing the report in terms of feeding back around, I guess, what's been helpful in terms of having a two-way channel of communication. I think that would be very helpful in terms of ensuring that expert witnesses are sort of meeting the needs of the criminal justice system. So I'd pause there for now and see what comes up in the Q&A.
Thank you very much, Oliver. I found that really, really interesting. So thank you for that. We're obviously a bit later than had planned, so I'm going to move straight on to questions for the panelists. And I'm going to ask a question of Oliver first, because I know that he may have to jump out at 7 o'clock. So question first for Oliver. What agencies can solicitors refer children to in the event of a conviction? We are not really equipped to deal with the emotional impact, but recognise that there is one. So where can what agencies can solicitors refer children to if they receive a conviction?
Well, certainly within the NSPCC, the referral routes are via social workers. So a child would already be within social care, within children's services, that would be often funded. So often that's a very important referral route. because from a safeguarding perspective, it's important that there are other agencies involved, and often it's the local authority who sort of hold the safeguarding responsibility. So, and I would imagine in most cases where there has been a child who's been subject to an allegation or a conviction, then there would be children's services involvement, at least at the beginning. So yes, I would say that's. There's also, there's the Portman Clinic in North London. Again, I'm going to be a bit sort of London-centric here because those are the services I know, but they have referral pathways for children who have got caught up in the criminal justice system. One of the panelists has just, Michelle, has just commented on Lucy Faithful. I'd agree with that too. They're particularly useful, particularly with online offences. But equally, there's someone like NCATS, for example, in the NSPCC. We take inquiries, we can give advice and signposting. So would always invite that.
Great, that's great. Thanks, Oliver. And if you do need to jump off at 7, if we do go a couple of minutes over, just do so. So a question now for Maeve. How do you deal with balancing the availability of out-of-court disposals if admissions were made with the protection of a no-comment interview? It feels like a much bigger risk in comparison to other types of cases, Maeve.
So just I want to make sure I understand the question. So when there's a no-comment interview,
well, where there's potential for availability for an out-of-court disposal, but if admissions are made, they may get an out-of-court disposal, but balancing that with the protections of having a no-comment interview. It seems it's quite in these kind of cases it's even more of a balancing act.
Yeah, no, you're absolutely right, and it is so fact sensitive, to be completely honest, and it can be really actually quite a difficult thing to navigate when you're at the police station and you're trying to weigh up those considerations about what do we say, do we want to make an admission to this part. With sexual offences in particular, it's such a broad range of activities, and you have a spectrum of behaviours where some of it will very clearly fall into offending behaviour, but you've got this whole grey part where you have exploration, experimentation, misunderstanding, finding boundaries, and it can be really difficult, particularly if you're just brought into the police station, to be understanding of that full context and having a holistic view of where that young person is and all those factors that are really important at that time. So, while you need to hedge your bets and say, right, do you want to just get admissions in early, try and get an out-of-court disposal, try and deal with this as quickly as possible? I just think it's so case and fact sensitive that, if you're there at the time and a no comment is the right thing to do, that doesn't mean that you can't follow up and say, look, we've got this evidence, you've got this evidence, let's look at another way of approaching it.
Thank you very much, Maeve. A question for Ben now. Do you think children really have a fair trial in the youth court, where district judges are less robust in applying the rules of evidence and allowing disclosure of third-party evidence, such as victims' school records or social media or phone records, for example?
I have to say, I find it very difficult to advise a client to stay in the youth court when we can have any kind of influence on it at all. I'm a firm believer in the fairness that you get with trial by jury, and it would only be in a very specific situation that I would rather be in the youth court. I think what's frustrating now, as I touched on in the talk, is the fact that it's a lot harder to get out of the youth court. But I completely agree with the premise of that question, that when dealing with district judges in the youth court, first of all, you've got the natural case hardness of an experienced district judge, and they normally will be quite experienced district judges who've got youth court tickets. But with that comes the fact they're even more case hardened. Also, you have the difficulty that because you're being tried by a tribunal who can also sentence you, you get that difficulty all practitioners have had with being tried by a district judge, that if you know that you can deal with a case in a certain way, you can convict and then sentence in a certain way. And all practitioners have had cases where a district judge has given a soft conviction and then a soft sentence, which doesn't leave anyone satisfied. And certainly certainly, I've had recent experiences of that in the youth court. And it can be beneficial when you come to sentence, because I think a youth tribunal will generally always be better. But I would say if you're going to have a contested trial and you've got a client who has good character on the line, that's the main issue. If you can get a jury, you want a jury.
Thank you very much, Ben. I think we have, let me just check out where we've got another one for, well, we've got another one for Ben, but let's ask Maeve. Got one here. What happens if a child is, you sort of did talk about this in your presentation, but it's what happens if a child is under investigation for an offence, which we've talked about today, allegedly committed, aged 16, but it's now 18 with no outcome. So it's what we've been talking about today, the delays.
That is such an important point, and it's one you just can't make enough, and it's something we're seeing so often now with all the delays, just generally in the criminal justice system. And because there isn't any fast track for youth cases when they're coming up to an age threshold, sometimes we can really have to engage with the police quite a lot and say, look, this is coming up. What stage is the investigation at, and try and push them to actually make a decision before they meet that age threshold. Because once you turn 18, those protections are not there anymore. And there's not really any way that you can get them back. There just isn't. And it is deeply, deeply unfair. And we have seen so many times clients have come to us and they've been under investigation for the best part of 2 years, and then they get a postal requisition 1 week after their 18th birthday, and suddenly they're being treated like an adult. It is just absolutely horrific, quite frankly. So yeah, to the person that asked that question, that does happen. It happens all the time, and it's something that we need to be, we diarise our clients' birthdays to make sure that we've got enough good time to raise those issues early on.
That's a good idea, Maeve, because again, we see the same thing through our legal advice line a lot with those kind of cases. So yeah, these cases. So it's a good point. Next question is for Ben. What impact do you think the use of Section 28 cross-examination of victims in advance of trials had on the fairness of proceedings in the Crown Court, and how will this play out when expanded to the Youth Court?
Oh, that's a really interesting question. I think in terms of fairness, I'm not sure that Section 28 in and of itself significantly undermines the fairness of trial proceedings, because ultimately, if everything is done properly and you've gone through all the phases of disclosure before you cross-examine, then really what you could say is that it's slightly unfair on a young defendant that they don't get the same benefit of everything being brought forward, and they have to experience the delay of their trial being much later. Because I think part of the reason that Section 28 has become an attractive proposition is partly to do with all the delays in the system and the fact that trials take so long to get on. If people are being tried in a reasonable time, and particularly in a reasonable time after they've entered not guilty pleas, there'll be a lot less need to have Section 28. It's really the fact that defendants on bail, as they often are in sex cases, the trials are so far off that there is that added reason to do it. There are, of course, other justifications for Section 28 as well, in terms of the circumstances in which it's done for the complainant. But it's not so much that concerns me with Section 28. It's more that by breaking the process up, it elongates the whole trial process. And I think for a child, you're basically having a situation where you're really being tried twice, because you're turning up at court for the Section 28, which is really significant, having the complainant give evidence against you, be cross-examined. You've got to be trial ready for that. Everyone's got to be trial ready. You've got to have had all your instructions. You've got to be ready to go, really. And so you build yourself up for that. You've got the trauma of coming to court for it. And then, of course, everyone down tools for 4 months, 5 months, 6 months, maybe even longer before you come back. And I think what for practitioners is a frustrating experience of effectively having to turn up for trial twice, for a child could be really quite disturbing and make the process a lot harder for them.
I think, yeah, thank you very much for that, Ben. That was great. Oliver, I think if you've got time quickly before you need to go, there is one question for you. What do you recommend for supporting children who are subject to allegations, particularly those in a custodial setting, who may be on remand for serious sexual offences where the nature of the environment means they are in fear of others finding out about their offence?
Yeah, I mean, that's very tricky, particularly those who are vulnerable. I mean, it's of course there are healthcare wings in these environments. That doesn't necessarily stop the child feeling very unsafe, and I mean, there is no short or quick answer to how that child can be supported in terms of reaching out to the support that's available within the within an institution itself, which can be quite patchy at times. Yeah, I've certainly had experience of being in youth offender institutions, for example, was incredibly good welfare, and others with much less so. I mean, many secure children's centres have closed down, and not so recently. So yeah, the advice would be to speak out to one of the healthcare professionals.
Thank you very much, Oliver. I think we'll just do one final question before we finish, and that's for Maeve. That's what can we do about delay, and when does the delay become an abuse of process?
That's a tricky question, because, you know, everybody that works in this space knows that the delays are chronic. And although they have an impact on anybody caught up in the justice system, for a young person, you just can't really quantify how much that can impact their life. But there are ways, I guess, sometimes to use it to your advantage if you can. So in that case I mentioned just a moment ago, where we had a child that was charged just a week after their 18th birthday. We made representations to the CPS and just sort of said, really? Like, really? Did that take that long to investigate? We saw the lines of inquiry that they had to look at, and we said, that would have taken just a couple of months, you know? Give us a reason for this delay. And they were unable to, and in that situation the case was discontinued. So there's not really much, in my view, as a practitioner, you can do about the delay, except just continue to engage, try and keep your case at the top of any individual's pile who's looking at it, raise the fact that a delay, you know, is impacting them. And, you know, when it's unavoidable, think about how you might be able to spin it into something that could be useful. So, you know, again, if there is offences that are said to have happened when somebody was 16 and they're now 18, look at how maybe their life has changed. Have they grown out of those behaviours? And you can point to 2 years where they've not had any other interactions or issues. There's lots of arguments that can be made. So I wish I could just magic and say, let's get all these delays sorted. But it feels like something we're just going to have to navigate and deal with for the foreseeable. Thank you. I think that's a good place for us to end. So yeah, thank you very, very much to all the speakers. Really appreciate it. Really interesting. It's great that I thank you all for coming along. Just to mention, the guides are all available on our website, and if this webinar will be up on recorded in the next couple of days. And just a reminder before everyone goes to check out our training and membership model that we just launched last week. So go on our website or contact me or Katia directly if you have any questions about that. But yeah, thanks everyone for coming along.